Welcome to the deep dive. You see the President of India in photographs, greeting world leaders, presiding over ceremonies, living in that magnificent Rashtrapati Bhavan. There's this image of immense power, the head of the country, right?
Right, that visual is very strong.
But what is the actual job? Is the president the ultimate decider? Or is there something more intricate going on behind that powerful facade, something, rooted deep in India's constitutional design?
That perception versus the reality is exactly what makes the office so fascinating. Today, we're doing a deep dive specifically into the office of the President of India, pulling insights directly from a comprehensive look at a key text on Indian polity.
Okay, a deep dive. And our goal really is to get you a solid understanding of the president's place within India's system, how they get there, what their many powers are on paper, and critically, how those powers actually function in practice.
Exactly. We want to unpack the constitutional structure.
Understand the unique election process, explore the different facets of their authority, and grapple with that central question: how much real power does the Indian president truly wield?
And there are definitely some surprising nuggets in the source material that challenge common assumptions. It's not always straightforward.
Let's start then. Where does the president fit in the overall governmental framework? Our source material places them in Part B of the Constitution.
That's right. Part V, which deals specifically with the union executive, so the central government's executive branch.
Okay, the union executive.
Yeah.
So not just the president then.
No, exactly. Part V, spanning Articles 52 to 78 of the Constitution, lays out the structure. And according to our source, the president is part of a larger team. That includes the vice president, the prime minister, the council of ministers, and also the attorney general of India.
Right, a whole team. So the president is at the head of the structure, but they are one component of it. What is their fundamental role within this executive setup?
Well, the source defines the president's primary role very clearly. They are the head of the Indian state.
Head of state.
Think of them as the formal head, the first citizen of India. Their function is deeply symbolic. They act as the symbol of unity, integrity, and solidarity of the nation.
A symbol of unity. That makes sense.
But while they head the state, their position is distinct from being the head of the government. That, as we know in a parliamentary system, is the prime minister.
That distinction between head of state, president, and head of government, PM, is crucial for understanding India's system, isn't it?
Absolutely fundamental.
So the president is the symbol, the formal head. But how do you choose this symbolic leader of, well, over 1 billion people? This brings us to the election process. It's definitely not a direct election like in some other presidential systems, is it?
No, not at all. And that's a key foundational difference our source highlights right away. The president is not elected directly by the people. This was a very deliberate choice by the Constitution makers.
Right. So if not the people directly, who does elect the president? The source talks about an electoral college.
Yes. The election is conducted by a specially constituted electoral college. The source is quite specific about its composition.
Okay, who's in it?
It includes only the elected members of both houses of parliament, that's the Lok Sabha and the Rajya Sabha.
Elected members of parliament. Got it.
And it also includes the elected members of the legislative assemblies of all the states.
Elected MLAs, too. And wasn't there an addition to this college later on? Some union territories.
That's right. The elected members of the legislative assemblies of the union territories of Delhi and Puducherry were added. Our source notes this came into effect on June 1st, 1995, following the 70th Constitutional Amendment Act of 1992.
Okay, so it's a group of elected legislators from the national parliament and the state and specific UT assemblies. Seems straightforward enough. But then who is not included? The exclusions are just as important, I imagine.
They are, yes. The source makes the exclusions very clear, and this helps understand the representational logic. Excluded are the nominated members of both houses of parliament.
Nominated MPs are out.
Also excluded are the nominated members of the state legislative assemblies, and crucially, the members both elected and nominated of the state legislative councils.
The legislative councils, the upper houses in some states, they're completely out.
Completely out of the presidential election process. Also excluded are the nominated members of the legislative assemblies of Delhi and Puducherry. Basically, if you're nominated, you don't vote for the president.
And the source mentions that the recent change regarding Anglo-Indian nominations also plays into this exclusion.
Yes, that's relevant. The 104th Constitutional Amendment Act of 2019, which came into effect January 25, 2020, discontinued the provision for nominating Anglo-Indian members to the Lok Sabha and state legislative assemblies. So That specific category of nominated members previously excluded, while they simply don't exist in Parliament or state assemblies anymore in that form.
Okay. What happens if a state assembly is dissolved before the presidential election? Let's say elections are due but haven't happened yet. Do those former members still get a vote?
Good question. Our source addresses this specific scenario. It states that if a state assembly is dissolved, the members of that dissolved assembly cease to be qualified to vote in the presidential election.
Even if new elections haven't been held?
Even then, the focus is on the currently existing elected members of functioning assemblies at the time of the presidential election. A dissolved assembly means no representation from there in that particular election.
That makes sense for keeping the college current. Now, this college includes members from states with vastly different populations, Uttar Pradesh versus, say, Sikkim. How do they ensure fairness and balance, make sure votes are weighted somehow? This is where the value of votes comes in, right?
Yes, and this is probably one of the most unique and, let's say, complex aspects of the Indian presidential election. It's designed to achieve two key constitutional principles.
Which are?
Uniformity in the scale of representation among the different states themselves, and parity between the states as a whole and the union.
Uniformity among states and parity between states and the center. Okay.
So it's not a simple one legislator, one vote system. Each MLA's vote has a calculated value, and each MP's vote has a different calculated value. It's a weighted system.
Right. So how is the value of an MLA's vote determined? What's the formula?
Okay, for an elected member of a state legislative assembly, an MLA, the value of their vote is calculated based on their state's population. The formula is you take the total population of the state, divide it by the total number of elected members in that state's legislative assembly.
Population divided by number of elected MLAs.
And then you multiply that result by 1,000, or divide by 1,000. So state population elected MLAs, 11,000.
So here's a crucial detail from the source, which always surprises me.
Right.
Which population figures are used? It's not the most recent census, right?
No, absolutely not. And this is a really important point. The population figure used in this calculation is based on the 1971 census figures.
1971. Why so far back?
Well, according to the 84th Constitutional Amendment Act of 2001, these figures are frozen and will continue to be used until the first census taken after the year 2026 is published.
But why 1971 specifically? What was the rationale?
The rationale, as highlighted in our material, is actually quite insightful. It was done primarily to avoid penalizing states that had been successful in implementing population control measures since 1971.
So if they used later figures, states that control population growth would have less weight.
Exactly. They would have fewer citizens represented per MLA compared to states with higher growth, leading to a lower vote value per MLA. This could have reduced their overall influence in the presidential election, which was seen as unfair and, frankly, counterproductive to national family planning goals.
Yeah.
Using the 1971 baseline sort of froze that distribution based on population control success.
That puts a different spin on using old data. It's linked to a policy objective, not just outdatedness.
Yeah.
Okay, so that's the MLA vote value. How about the value of an MP's vote? How is that calculated?
The value of a vote for an elected member of Parliament, MP, is calculated to ensure that principle of parity between the states and the union. You take the total value of votes of all the MLAs from all the states combined.
So sum up all the calculated MLA vote values nationwide.
And you divide that grand total by the total number of elected members of both houses of Parliament, Lok Sabha plus Rajya Sabha.
So total value of all MLA votes, total elected MPs.
Precisely. This calculation aims to make the total voting strength of the union's elected MPs roughly equal to the total voting strength of all the states' elected MLAs combined. Parity.
Our source even provides figures from the 2022 election to show this in action. It gives a sense of the scale involved.
Yes, the table in the material is helpful. It shows how the MLA vote value varies dramatically. You have states like Uttar Pradesh with a value of 208 per MLA, reflecting its huge 1971 population, down to states like Sikkim with a value of just 7 per MLA.
Huge difference.
For the 2022 election, the total value of votes for all MLAs nationwide summed up to 5,043,231. The total number of elected MPs at that time was 776. That's 543 from Lok Sabha plus 233 from Rajya Sabha. So you divide the total MLA value by the total number of MPs, 5,043,231 divided by 776.
And that gives?
It gives a value of 700 for each MP's vote in that 2022 election.
700 per MP. And the grand total value of all votes in the Electoral College in 2022 was?
Well, you add the total MLA value, 5,043,231. And the total MP value, so 776 MPs, 700 value MP equals 5,043,200. So 5,043,231 plus 5,043,200 equals 10,086,431.
So it's clearly a system where the weight of the vote matters immensely, not just the number of voters.
Absolutely. It's designed to reflect that federal balance we talked about.
Right, a weighted system.
Okay.
How is the actual voting conducted within this college? The source talks about proportional representation by means of the single transferable vote,
Yeah.
or PR by STV.
Yes, that's the system specified in the Constitution. The election is held using proportional representation by means of the single transferable vote, and it's conducted by secret ballot.
Now that always sounds a bit complicated, especially since they're only electing one president. What's the point of proportional representation and single transferable vote for a single seat? Usually, you hear about PR for multi-member constituencies.
That's a fair point. The terminology can seem odd, but the goal here, according to our material, isn't proportionality in the usual sense. It's about ensuring that the successful candidate secures an absolute majority of the valid votes polled, not just a simple plurality where the top candidate might win with, say, only 30% of the vote.
So STV is the mechanism to guarantee a majority winner.
Exactly. The STV mechanism, even for a single seat, helps achieve this by transferring preferences from eliminated candidates until one candidate crosses that absolute majority threshold.
How does that threshold, the quota, work? How do they figure out how many votes someone needs?
There's a specific formula for the quota. You take the total number of valid votes polled divided by the number of candidates to be elected plus one.
Which is always 1 for president, so divide by 1 plus 1 equals 2.
Right. So divide the total valid votes by 2, and then you add 1 to the result. So total valid votes polled 2 plus 1. Basically, you need just over half the valid votes.
Simple majority, essentially.
Yeah.
Okay. And the ranking system with STV. How do voters express their choice?
Each member of the Electoral College gets a single ballot paper, but instead of just putting an X next to one name, they indicate their preferences. They mark 1 for their first choice, 2 for the second choice, 3 for their third, and so on, for as many candidates as they wish to rank.
So voters rank their preferences. 1, 2, 3. How is the counting done, then, to reach that quota?
It's a multi-stage process if no one wins outright on first preferences. First, all the first preference votes, the ones for each candidate, are counted. If any candidate receives enough first preference votes to meet the required quota, they're declared elected right away. Game over.
And if nobody gets the quota in the first round?
That's when the vote transfers begin. The candidate who received the lowest number of first preference votes is eliminated from the race.
Okay, lowest candidate out.
Then, the ballot papers of that eliminated candidate are examined. The second preference, marked on each of those ballots, is then added to the vote count of whichever remaining candidate was marked as the second choice.
So the votes aren't wasted. They transfer according to the voter's next preference.
Precisely. And if after this transfer of votes, a candidate now reaches the quota, they are elected. If not, the process repeats. The candidate now having the fewest votes is eliminated, and their votes are transferred based on the next available preference marked on their ballots, which might be the second, third, or even later preference, depending on who's still in the running.
And this continues, round by round, eliminating the lowest candidate and transferring their votes until someone finally gets over that 50% plus 1 mark.
That's exactly it. It continues iteratively until one candidate secures the necessary quota and is declared the winner. It's designed to build a majority winner based on the accumulated preferences of the electors.
That's a very specific mechanism, clearly aimed at ensuring broad acceptance for the winner within the Electoral College. What happens if there's a dispute about the election results? Who decides?
Our source is very clear on this. All doubts and disputes related to the president's election are inquired into and decided exclusively by the Supreme Court of India.
Only the Supreme Court.
Only the Supreme Court. And its decision in these matters is considered final. There's no appeal beyond that.
Can the election be challenged just because there were some vacancies in the Electoral College when the election happened? Maybe some seats were empty?
No, the material explicitly states that the election cannot be called into question simply because the Electoral College was incomplete due to existing vacancies among the members entitled to vote. This prevents any strategic attempts to invalidate an election based on, unavoidable vacancies.
And a practical question. Let's say the Supreme Court does declare a president's election void after they've been in office for a while. Are all the decisions that person made, all the laws they signed, suddenly invalid? That sounds chaotic.
Thankfully, no. The source clarifies that point. If the Supreme Court declares the election of a person as president void, the acts done by that person before the date of the Supreme Court's declaration remain valid and are not invalidated.
Phew. That's crucial for maintaining continuity and stability.
Absolutely. It prevents retrospective chaos.
So we've seen this unique indirect election system. Weighted votes, STV, designed to balance federal representation and ensure a majority winner. Our material mentions debates in the Constituent Assembly about this choice. Why did they opt for indirect election despite some arguing it was, well, undemocratic not to let the people vote directly?
This was a significant debate, yes. Some members did strongly favor direct election. However, the Constitution makers ultimately settled on the indirect method for several key reasons highlighted in the source.
What was the main one?
Firstly, they believed it was more in harmony with the parliamentary system India was adopting. Remember that core distinction. President as head of state, PM as head of government. In this system, the real executive power rests with the Prime Minister and Council of Ministers who are responsible to Parliament. The president is intended to be the nominal executive, the formal head.
And a direct election for a nominal head would be weird.
It was seen as anomalous, yes. It could create confusion or even conflict with the Prime Minister's role. You might have a directly elected president feeling they have a mandate from the people to govern directly, clashing with the principle of the Council of Ministers being accountable to the elected legislature. Two competing centers of power based on popular vote.
That makes sense. Avoids a clash of mandates. What were the other reasons?
A second, very practical reason cited is the sheer scale, cost, and time required for conducting a direct presidential election across a country as vast and populous as India. It would be an enormous undertaking, involving huge expense and effort, deemed perhaps unnecessary for a largely symbolic head.
So efficiency and costs were factors too.
Definitely.
And they also rejected the idea of having only Parliament elect the president. Why not just let the MPs choose?
Yes, that was another option, considered elections solely by the members of Parliament. But the Constitution makers had a concern there too. They worried that if Parliament was dominated by one large political party, electing the president might become a purely partisan exercise.
The ruling party could just install their preferred candidate.
Potentially, yes. And such a president might not adequately represent the states or be seen as impartial. The current system, by including the elected MLAs from the states, ensures the president is elected by representatives of both the union and the states. It reinforces the federal character of the office and makes the president a representative of the entire nation, not just the party in power at the center.
That's a powerful point, the president as a symbol of the union and the states, chosen by both levels. Our material even mentions some technical debate in the assembly about the terminology used, like proportional representation for a single seat being a bit of a misnomer.
Yes, it's a small detail from the Constituent Assembly discussions mentioned in the source. Some members argue that terms like proportional representation are typically associated with multi-seat elections and might be technically inaccurate when you're electing just one person.
What did they suggest instead?
They suggested terms like preferential system or alternative vote system might be more precise descriptions of the STV mechanism used for electing a single president. It just highlights the level of detail and the sometimes nuanced disagreements that went into the drafting process. They really thought through these things.
Fascinating details about the why behind the system. Now that we know how they get elected, let's look at the requirements and conditions of the office itself. Section 3 in our outline. Qualifications, oath, and conditions. Who is eligible to even be considered for president?
Okay, the source lays out the essential qualifications. Pretty straightforward. First, the person must be a citizen of India.
Obvious enough.
Second, they must have completed 35 years of age.
Minimum age of 35.
Third, they must be qualified for election as a member of the Lok Sabha, the House of the People. So they need to meet the basic criteria to be an MP in the lower house.
Okay, citizen, 35, qualified for Lok Sabha. And the fourth qualification relates to holding other offices, the Office of Profit rule.
Yes, that's the fourth one. The person must not hold any office of profit under the union government, any state government, any local authority, or any other public authority. The idea is to ensure the president is independent and not beholden to other governmental roles.
Are there specific exceptions to that Office of Profit rule? Can, say, a current governor run?
Yes, the source clarifies that certain current office holders are explicitly not deemed to hold an office of profit for the purpose of presidential eligibility. These exceptions include a sitting president or vice president of the union, the governor of any state, and a minister of the union or any state. So yes, a governor or a minister can definitely be a candidate while still holding their position.
Okay, so they meet the qualifications. How do you actually get your name on the ballot paper? Is it easy to just declare candidacy?
Not at all. To be nominated as a candidate for the presidential election, you need significant backing from within the Electoral College itself. Your nomination paper must be subscribed by at least 50 electors as proposers
50 proposers.
and another 50 electors as seconders.
50 seconders. So 100 members of the Electoral College have to actively support your nomination just to get on the ballot. That's quite a hurdle.
It is. And our source notes this number was significantly increased. Before 1997, it was only 10 proposers and 10 seconders.
Why the big jump?
The change was made specifically to discourage non-serious candidates, people who didn't really have a realistic chance or broad support, from entering the race and cluttering the ballot. It ensures candidates have a certain baseline level of genuine support among the actual electors.
Makes sense. And there's a financial deposit involved as well, isn't there?
Yes, there is. Each candidate must make a security deposit of $15,000 with the Reserve Bank of India.
15,000 rupees.
At.
And you can lose that deposit.
You certainly can. The deposit is forfeited if the candidate fails to secure at least 1/6 of the total valid votes polled in the election. Our source also mentions this amount was increased too from $2,500 before 1997, again, part of that same effort to deter frivolous candidacies.
Okay, so eligibility, nomination. Once someone is elected, there's a formal step before taking office, the oath. What does the president actually promise in their oath?
It's a very significant moment. Before assuming office, the president takes an oath or makes an affirmation. The source details the 3 core commitments they swear to uphold.
Where are they?
First, to faithfully execute the office of president. Second, and this is crucial, to preserve, protect, and defend the Constitution and the law. And third, to devote themselves to the service and well-being of the people of India.
Preserve, protect, and defend the Constitution. That sounds like a very weighty responsibility.
It absolutely is. It underscores their role as the ultimate guardian of the constitutional framework.
Who administers this oath?
The oath is administered by the Chief Justice of India. If the Chief Justice is unavailable for some reason, then the senior-most judge of the Supreme Court who is available administers it. The source also adds that anyone acting as president, like the vice president stepping in, takes a similar oath.
Got it.
Yeah.
What about the ongoing conditions of the office once they're sworn in? Are there rules about what they can and can't do?
Yes, the Constitution lays down specific conditions. For instance, the president cannot be a member of either House of Parliament or a state legislature. If they are an MP or MLA when elected president, they're deemed to have vacated that seat on the day they enter the president's office.
So no holding 2 positions.
Correct. And they also cannot hold any other office of profit during their term.
And they have official entitlements, like the residents?
Yes, they are entitled to use the official residence, the magnificent Rashtrapati Bhavan, without paying rent. They also receive emoluments, allowances, and privileges as determined by Parliament. And there's a key constitutional protection here. Their emoluments and allowances cannot be reduced during their term of office. This is important to safeguard their financial independence from political pressures.
Our source even gives us the updated salary figures, right?
It does. It notes the president's salary was increased quite substantially, from 1.50 lakh per month to 5 lakh per month in 2018, and that was made effective retrospectively from January 1st, 2016. The pension for retired presidents was also increased back in 2008 to 50% of their monthly salary.
So, quite comfortable compensation. And the entitlements extend beyond the president's term. For former presidents.
Yes, definitely. Former presidents receive significant post-retirement benefits. This includes things like a furnished residence, a phone, a car, medical care, travel facilities, secretarial staff, and office expenses up to $1,000 per year.
And even for the spouse of a deceased president.
Yes, the source mentions that too. The spouse of a deceased president receives a family pension, which is 50% of what a retired president gets, and they also get similar entitlements like a residence, phone, medical care, travel, and office expenses up to €20,000 per year. It's a recognition of the service and status associated with the office.
What about legal protections during their term in office? Can the president be sued or prosecuted?
The president enjoys considerable immunity while in office. They have personal immunity from any legal liability for their official acts. What they do in their capacity as president, they can't be dragged to court for.
And for things unrelated to their job? personal acts.
Even for personal acts, they have immunity from criminal proceedings during their term. No criminal case can be started or continued against them, and they cannot be arrested or imprisoned on criminal charges while they are president.
Complete criminal immunity during the term. What about civil matters? Can someone sue them personally?
Civil proceedings can be initiated against the president for their personal acts during their term of office, but there's a procedural safeguard. It can only happen after a mandatory 2 months prior notice has been given to the president. So accountability for personal civil wrongs is possible, but with a notice period.
Okay, that covers qualifications, the oath, and the conditions, benefits, and protections. Now let's move to Section 4 in the outline. Term, impeachment, and vacancy. What's a standard term length for the president? How long do they serve?
The president holds office for a term of 5 years from the date they enter upon their office, the date they take the oath.
5 years. Can they leave office earlier than that 5-year mark?
Yes, there are a couple of ways they can leave office before the term is up. They can choose to resign, in which case they submit their resignation letter addressed to the vice president.
Resignation to the VP. What's the other way?
The other way is removal from office through the process of impeachment, which we should probably discuss in more detail.
Definitely. But before impeachment, our source mentions a provision to ensure there's never a gap in the office, even if the 5-year term expires. How does that work?
Ah, yes. This is a vital point for the continuity of the head of state rule. The Constitution includes a provision stating that the outgoing president continues to hold office, even after their 5-year term has officially expired, until their successor is elected and enters upon their office.
So no interregnum or gap is possible.
Exactly. It prevents any situation where the country is temporarily without a president. And interestingly, the source notes that in this specific scenario, where the term has expired but the successor hasn't taken charge yet, the vice president does not step in to act as president. The incumbent president simply continues until the handover.
It's a neat constitutional safeguard. Now, is there a limit on how many terms a person can be elected president in India? Can they run again?
Yes, they can. Unlike the system in some other countries, like the USA, where a president is limited to 2 terms, the president of India is eligible for re-election for any number of terms. There's no constitutional limit.
Any number of terms. Has anyone actually served more than 1 or 2?
The source notes that so far in India's history, only the first president, Dr. Rajendra Prasad, has served 2 full terms. But constitutionally, there's no bar on serving more.
That unlimited re-eligibility is another interesting feature. Now, let's talk about that other way of leaving office early. Impeachment. The ground mentioned in the Constitution is violation of the Constitution. What does that actually mean?
That is indeed the sole ground stated for impeachment. Violation of the Constitution. However, a very notable point our material makes is that the Constitution itself does not provide any specific definition of what constitutes a violation of the Constitution.
So it's undefined. Who decides what it means then?
It's left to Parliament to interpret in the context of an impeachment proceeding. This ambiguity is quite significant.
Okay. How does the impeachment process actually start? Where can it begin?
The process can be initiated in either House of Parliament. It can start in the Lok Sabha or the Rajya Sabha.
Either house can kick it off. And what are the specific steps involved? It sounds like a serious process.
It is, and it has very high thresholds. First, to even initiate the charges, a resolution containing the charges must be signed by at least 1/4 of the total members of the House that is proposing the charges.
1/4 of the House just to start the discussion.
Yes. Then, a 13-day advance notice must be given to the president before this resolution is actually moved in the House.
14 days notice to the president. Then what?
If that initiating House then discusses the charges and passes the resolution by a special majority, specifically a majority of 2/3 of the total membership of that House, then the resolution, along with the charges, is sent to the other House.
2/3 of the total membership, not just those present and voting. That's a very high bar.
It's extremely high. So if the first House passes it, it goes to the second House. What role does the second House play? The second House then investigates the charges that have been framed and passed by the first House. It acts almost like a court in this phase. And during this investigation, the president has the right to appear and to be represented, perhaps by lawyers, to defend themselves against the accusations.
The president gets to present their case.
Yes. If, after the investigation, the second House also sustains the charges and passes the impeachment resolution by that same special majority, 2/3 of its total membership, then the president stands removed from office from the very date that resolution is passed by the second house.
Wow. So it requires that incredibly high IRE, two-thirds majority of the total strength in both houses. Our source calls this a quasi-judicial process happening within Parliament.
It is. It has elements of a trial conducted by the legislature. And the source highlights a really interesting difference in who gets to participate in impeachment compared to who participates in the election of the president.
Ah, yes, that distinction. Who's in for impeachment, but wasn't in for the election, and who's out for impeachment, but was in for the election.
This is a key structural point. The nominated members of both houses of parliament, remember, they were excluded from the election. They can participate in the impeachment proceedings.
So nominated MPs vote on impeachment?
Yes. Conversely, the elected members of the state legislative assemblies and the UT assemblies of Delhi and Puducherry, who are the crucial state component of the Electoral College for election, they do not participate in the impeachment process at all.
So state MLAs have no role in removing the president?
None whatsoever. Impeachment is a purely parliamentary removal mechanism involving both elected and nominated MPs, but excluding state legislators entirely.
Has any Indian president ever actually been impeached?
Our source confirms that no president of India has been impeached so far. The process has never been completed.
Good to know. Okay, let's look at other reasons for a vacancy occurring before the 5-year term is up. Besides resignation or impeachment, how else can the office become vacant?
Well, tragically, a vacancy can occur due to the president's death while in office. Our source specifically mentions 2 presidents who passed away during their tenure, Dr. Zakir Hussain and Fakhruddin Ali Ahmed.
Death in office. Any other ways?
A vacancy can also occur otherwise, which is a bit of a catch-all. This could cover situations like the president becoming disqualified to hold office for some reason after being elected, or if their original election is declared void by the Supreme Court, as we discussed earlier.
Right. If a vacancy occurs in one of these ways, by resignation, death, removal, or otherwise, how quickly does the election for a new president have to happen?
The Constitution mandates that an election to fill such a vacancy must be held within 6 months from the date the vacancy occurs.
Within 6 months. Okay. And the person who gets elected to fill this midterm vacancy, do they just complete the remaining part of the previous president's 5-year term?
No, this is an important detail. The person elected to fill such a vacancy serves a full term of 5 years from the date they enter office. They don't just serve out the remainder. They get their own fresh 5-year mandate.
A full 5 years for the successor. What happens in that interim period, say, during those potential 6 months between the vacancy occurring and the new president being elected? Who acts as president?
The Constitution has clear provisions for this continuity. If the office of president falls vacant due to resignation, removal, death, or otherwise, the vice president of India automatically steps in and acts as the president until a new president is elected and takes office.
The VP takes over. What if the president isn't vacant but just temporarily unable to function? Maybe illness or absence?
In that scenario, too, if the sitting president is temporarily unable to discharge their functions due to absence, illness, or any other cause, the vice president discharges those functions until the president is able to resume their office.
Okay, so the VP is the first backup. But what if the vice president's office is also vacant at the same time the president's office becomes vacant? Or if the VP is also unable to act? It seems unlikely. But is there a plan?
Yes. The Constitution and subsequent parliamentary law cover even this contingency. Our source explains that in such a situation where both the president's and vice president's offices are vacant, or both are unable to function, the Chief Justice of India acts as the president or discharges the president's functions.
The Chief Justice steps in. Wow. And what if, incredibly, the Chief Justice's office is also vacant?
Going one step further down the line of succession, if the CJI's office is also vacant, then the senior-most judge of the Supreme Court who is available assumes the role of acting president.
That's a remarkably comprehensive chain of succession. President, VP, Chief Justice, senior-most Supreme Court judge. Our source provides a real-life example of this actually coming into play, doesn't it?
Yes, it's a famous and quite dramatic historical instance from 1969. It started in May '69 when the then-president, Dr. Zakir Hussain, passed away in office.
Okay, so the VP steps in.
All right. The vice president at the time, V.V. Giri, began acting as president. However, a few months later, V.V. Giri decided he wanted to run in the upcoming presidential election himself, so he resigned from the office of vice president and thus also from acting president.
So now both the president's and VP's offices were vacant.
Exactly. This created the very situation the succession plan covers. For a brief period, from July 20 to August 24, 1969, the then Chief Justice of India, Justice M. Hidayatullah, officiated as the President of India.
The Chief Justice actually served as acting president.
Yes, until the presidential election was held and the newly elected president, who turned out to be V.V. Giri, assumed office. It perfectly illustrates how those contingency provisions are designed to work in practice.
That's quite a story. And while someone is acting as president, whether it's the VP, the CJI, or a judge, do they have the full authority and perks of the office?
Yes, the source clarifies that point. Any person acting as president or discharging the functions of the president enjoys all the powers and immunities associated with the office and is entitled to the same emoluments, allowances, and privileges as determined by Parliament for the president. They function fully as president during that period.
Okay, we've covered the fundamentals, how they're chosen, the rules for holding office, term limits, removal, and how vacancies are handled. Now let's delve into what the president actually does, the powers and functions. Section 5 gives us an overview. Our source lists quite a few categories of powers vested in the president.
Indeed. On paper, the president is formally vested with a very wide range of powers and functions under the Constitution. Our material categorizes these under 7 main headings to help organize them and make sense of the scope.
7 categories. What are they?
Okay, the list is 1. Executive powers, 2. Legislative powers, 3. Financial powers, 4. Judicial powers, 5. Diplomatic powers, 6. Military powers, and 7. Emergency powers.
Executive, legislative, financial, judicial, diplomatic, military, emergency. Wow. Looking at that list alone gives you a sense of the breadth of the office, at least formally.
It really does. It touches almost every aspect of governance.
That's a comprehensive list. Let's start breaking them down, beginning with Section 6, Executive Powers. What are the president's key functions in the executive realm?
Okay, a fundamental point is that all executive actions of the government of India are formally taken in the president's name. They are the formal authority behind every government decision, every order issued.
So government actions are done by order of the president.
Essentially, yes. The president also has the power to make rules specifying how orders and other instruments made and executed in their name should be authenticated so they are legally valid.
And they can make rules about how the government itself works.
Yes, they are empowered to make rules for the more convenient transaction of the business of the union government, and importantly, for the allocation of that business among the various ministers, how portfolios are divided, basically.
This leads into one of their most visible executive powers, appointments. Who are the major officials appointed by the president? This seems like a significant area of power.
It is, definitely. This is where the president formally exercises significant authority. Crucially, the president appoints the prime minister, and then, on the advice of the prime minister, the president appoints the other ministers in the council of ministers.
And these ministers serve?
Formally, they hold office during the president's pleasure, though in practice, this pleasure is exercised on the advice of the PM and is really contingent on maintaining the confidence of the Lok Sabha.
Right. Who else do they appoint? The Attorney General.
Yes, the president appoints the Attorney General of India, who is the government's chief legal advisor. The president also determines the Attorney General's remuneration, and the AG also holds office during the president's pleasure.
And the list goes on to other crucial constitutional and statutory bodies.
Yes, the list of presidential appointments is quite long and very significant. It includes the Comptroller and Auditor General of India, the CAG, the Chief Election Commissioner and other election commissioners, the chairman and members of the Union Public Service Commission, UPSC, the governors of all the states, the chairman and members of the Finance Commission, and, as the source says, so on, implying many other senior officials and heads of commissions.
So the president is formally the appointing authority for a huge number of key positions across the government. Can the president seek information directly from the government about its functioning?
Yes, that's another important executive power. The president has the right to seek any information from the prime minister relating to the administration of the affairs of the union, and also any proposals for new legislation that the government is considering.
So they could ask the PM what's going on?
They can. And related to that, they can also require the prime minister to submit for the consideration of the entire council of ministers any matter on which a decision has been taken by a single minister, but which has not yet been considered by the council as a whole.
So a check to ensure collective responsibility. If one minister makes a decision, the president can say, hold on, let the whole cabinet discuss this.
Exactly. It's a mechanism to ensure that major decisions have the backing of the entire cabinet, upholding that principle of collective responsibility, which is central to the parliamentary system.
The president also has powers related to appointing specific commissions or councils.
Yes, for instance, the source mentions they can appoint a commission to investigate the conditions of socially and educationally backward classes. They can also appoint an interstate council, which is meant to promote better coordination and cooperation between the center and the states, and also among the states themselves.
And what about their administrative authority over union territories?
That's a direct executive function. The union territories are directly administered by the president, usually acting through administrators whom the president appoints, like lieutenant governors or chief commissioners.
And they have special powers regarding scheduled areas and tribal areas.
Correct. The president has the power to declare any area as a scheduled area and possesses specific powers regarding the administration of both scheduled areas and tribal areas, often exercised through the governor of the state concerned.
That's a very broad sweep of executive responsibilities, from top appointments and rulemaking to seeking information, ensuring collective decisions, and direct administration of UTs in special areas. Now, let's turn to Section 7, legislative powers. Our source notes the president's unique position here. They are considered an integral part of Parliament, but they aren't actually a member of either house.
That's right. It's a key constitutional point. The Parliament of India consists of three parts: the president, the Lok Sabha, House of the People, and the Rajya Sabha, Council of States. So the president is formally part of the legislature, and they exercise several crucial legislative functions.
Like summoning and dissolving Parliament. That seems fundamental.
Yes, the president has the power to summon each House of Parliament to meet for its sessions. They also have the power to prorogue the houses, which means ending a session without dissolving the House itself. And, importantly, they have the power to dissolve the Lok Sabha entirely, which usually leads to fresh general elections.
Can they call both houses together?
Yes, the president can summon a joint sitting of both the Lok Sabha and the Rajya Sabha. This is typically done to resolve a deadlock between the two houses over the passage of an ordinary bill. Though it's worth noting, the source adds that such a joint sitting is presided over by the Speaker of the Lok Sabha, not the president.
They also address Parliament at the start of sessions, don't they? The president's address.
Yes, that's a major ceremonial and political event. The president delivers a special address to both houses of parliament assembled together at the commencement of the first session after each general election, and also at the commencement of the first session of every year.
And what's the purpose of this address?
This address is essentially prepared by the government and outlines the government's policies and legislative agenda for the coming session or term. It's like the government setting out its stall, delivered formally by the head of state.
Can the president send messages to Parliament at other times?
They can, yes. The president can send messages to either House of Parliament, whether it's concerning a bill that is currently pending in Parliament or regarding any other matter they wish to bring to Parliament's attention.
What about filling temporary vacancies in the presiding officer roles? If the Speaker and Deputy Speaker posts are both empty.
The president handles that too. If the offices of both the Speaker and the Deputy Speaker of the Lok Sabha fall vacant, the president can appoint any member of the Lok Sabha to perform the duties of the Speaker. Similarly, they can appoint a member of the Rajya Sabha to preside when the offices of both the chairman, who is the vice president, and the deputy chairman are vacant.
Ensure the houses can always function. Now, the president is also well known for their power to nominate members to Parliament, particularly the Rajya Sabha.
Yes, that's a significant power. The president nominates 12 members to the Rajya Sabha. These individuals are chosen from people who have special knowledge or practical experience in fields like literature, science, art, and social service.
Bringing outside expertise into the upper house.
Exactly. It's meant to enrich the debates and composition of the Rajya Sabha beyond purely elected politicians.
And historically, they also nominated members to the Lok Sabha, didn't they, from the Anglo-Indian community?
That's correct. Before that 104th Constitutional Amendment Act of 2019 took effect in 2020, the president had the power to nominate 2 members from the Anglo-Indian community to the Lok Sabha if they felt the community was not adequately represented in the House. That specific nomination power for the Lok Sabha has now been discontinued by the amendment.
Okay. The president is also involved in deciding if an MP should be disqualified.
Yes, if a question arises whether a member of parliament has become subject to any of the disqualifications mentioned in the Constitution or law, the president decides on that question. However, this power is exercised after obtaining the opinion of the Election Commission, and the Election Commission's opinion is binding on the president in these matters.
So they consult the EC and act on its advice. Now, a really significant legislative power involves the introduction of certain types of bills. Our source lists several kinds of bills that actually require the president's prior recommendation or permission before they can even be introduced in Parliament. This seems like a major gatekeeping role.
It is indeed a key gatekeeping function, particularly for financial matters and issues affecting states. The source lists several specific instances where the president's prior recommendation or previous sanction is mandatory.
What are the main ones? Money bills, for instance.
Yes, money bills absolutely require the president's prior recommendation before they can be introduced in the Lok Sabha. Also, any bill that involves expenditure from the Consolidated Fund of India needs the president's recommendation.
Bills affecting states.
Bills for altering the boundaries of states or creating new states also need the president's prior recommendation before introduction.
Are there others, perhaps related to finance or taxation involving states?
Yes, the list continues. Bills that affect taxation in which states are interested, meaning states get a share of the tax. Bills that seek to vary the meaning of agricultural income for income tax purposes, which affects states' revenue. Bills that affect the principles on which money is distributed to states. And bills that impose surcharges on certain taxes or duties for the benefit of the center. All these need the president's prior nod.
So basically, any bill with significant financial implications, especially those affecting the center-state balance or the public purse, needs the president's okay to even start its journey through Parliament.
That's a good summary. It ensures the head of state is formally aware of and approves the initiation of legislation with major financial or federal consequences.
And this requirement for prior presidential sanction even extends to certain types of bills introduced in state legislatures.
That's right. Our material notes one specific instance. A bill introduced in a state legislature that seeks to impose restrictions on the freedom of trade and commerce, either within that state or with other states, requires the president's previous sanction before it can be introduced in the state legislature.
Why would that be?
This is likely another aspect of the president's role in safeguarding the overall economic unity of the country, preventing states from enacting protectionist measures that could hinder national trade without central oversight.
Okay, so the president has a role at the beginning of the legislative process for these key bills. But their most direct and perhaps most discussed legislative power comes after a bill has been passed by both houses of Parliament. That's the veto power. Our source details what happens when a bill reaches the president's desk for assent under Article 111.
Right. Article 111 is central here. When a bill, other than a money bill or a constitutional amendment bill, has been passed by both houses and is presented to the president, they essentially have three options laid out in the Constitution.
What are the three options?
1, they can give their assent to the bill. If they do, the bill becomes an act, a law. 2, they can withhold their assent from the bill. If they do this, the bill ends there. It does not become law. 3, they can return the bill, if it's not a money bill, to the houses for reconsideration.
Return for reconsideration. But what if Parliament, after reconsidering it, passes it again and sends it back?
This is where the president's power is limited for ordinary central bills. If Parliament reconsiders the bill and passes it again, either with or without amendments, and presents it back to the president is then obligated to give their assent. They cannot withhold assent or return it a second time.
So Parliament can override the president's initial objection by passing it again. Now, our source breaks down the different types of vetoes the Indian president effectively has based on these actions.
Yes, political scientists usually classify the president's veto power based on how they interact with legislation into 3 types that are applicable in India: the absolute veto, the suspensive veto, and the pocket veto.
Absolute, suspensive, pocket. And the source explicitly states there's one type the Indian president does not have.
Correct. The Indian president does not possess what's called a qualified veto. A qualified veto, which the American president has, is one that can be overridden by the legislature, but only with a higher majority than required for initial passage. Since the Indian parliament can override the president's return with just an ordinary majority, it's not considered a qualified veto.
Okay, let's unpack the three they do have. First, the absolute veto. What does that mean in practice?
The absolute veto is essentially the president's power to simply withhold their assent from a bill passed by Parliament as allowed by Article 111. When the president exercises this power, the bill does not become an act and it effectively dies. It's a full stop.
When is this absolute veto typically used? It sounds quite powerful.
It's used quite sparingly, and according to our material, primarily in two main scenarios. Firstly, it has been used with respect to private members' bills, that is, bills introduced in Parliament by any MP who is not a government minister.
So the government can advise the president to block a bill initiated by an opposition MP or even a ruling party backbencher.
Yes. Secondly, and perhaps more significantly in constitutional terms, the absolute veto can be used on government bills in a specific situation. When the cabinet that originally got the bill passed has resigned after the bill passed Parliament, but before the president has given assent. If a new cabinet comes in and advises the president not to give assent to the bill passed by the previous government, the president can exercise the absolute veto.
So it can be used to stop legislation from a previous government that hasn't yet received the final sign-off. The source provides some historical examples for the absolute veto.
Yes, it does. One example cited is from 1954. President Rajendra Prasad withheld assent from the PEPISU appropriation bill. This bill was passed by Parliament during a period of president's rule in the state of PEPUS. By the time it reached him for assent, president's rule had ended, and the regular state government was back. On their advice, or perhaps the union government's advice reflecting the new reality, he withheld assent.
Interesting context. Another example.
Another one mentioned is from 1991 involving President R. Venkataraman. He withheld assent from the Salary, Allowances, and Pension of Members of Parliament Amendment Bill. Apparently, it was passed on the very last day of the Lok Sabha's term, possibly in haste, and crucially, it hadn't obtained the president's prior recommendation, which might have been required given its financial nature. So, assent was withheld.
Okay, that clarifies the absolute veto killing a bill. How about the second type, the suspensive veto?
The suspensive veto is exercised when the president uses that third option under Article 111, returning a bill, that isn't a money bill, back to Parliament for reconsideration. The term suspensive comes from the fact that the president hasn't killed the bill outright, but merely suspended its journey into law by sending it back for a second look.
Sending it back for Parliament to think again. But, as you said, if Parliament sends it back a second time.
This is the key limitation for the suspensive veto on central legislation. If Parliament passes the bill again, either exactly as it was, or with amendments and sends it back to the president must give their assent. They have no further power to delay or block it. The suspension is overridden.
So unlike the U.S. system, where Congress usually needs a supermajority, like 2/3, to override a presidential veto, in India, Parliament just needs a simple, ordinary majority after reconsideration.
Exactly. Our source highlights this difference quite clearly. The Indian Parliament can override the president's suspensive veto relatively easily by simply passing the bill again with a simple majority of those present and voting in each house. The president's objection doesn't require a higher bar to overcome.
Does the suspensive veto apply to money bills? Can the president send those back?
No, the president cannot use the suspensive veto on money bills. For money bills, the president's options under Article 111 are limited to either giving assent or withholding assent, the absolute veto. They cannot return a money bill for reconsideration.
And why is that?
In practice, withholding assent from a money bill is also highly unlikely because money bills can only be introduced in the Lok Sabha in the first place with the prior recommendation of the president. So the president has already agreed to its introduction. Sending it back later would be contradictory. Assent is almost always given.
Right. That brings us to the third type, the pocket veto. This one sounds intriguing. It implies the president just holds onto the bill and does nothing.
That's precisely what it is. The pocket veto refers to the situation where the president takes no action at all on a bill presented for their assent. They neither give assent nor withhold assent, absolute veto, nor return it for reconsideration, suspensive veto. The bill is simply kept pending on the president's desk indefinitely.
Why is the president able to do that? Is there no deadline in the Constitution for them to act?
This veto is possible precisely because, as our source points out, the Indian Constitution does not prescribe any time limit within which the president must take a decision, give assent, withhold, or return on a bill presented for their assent.
No time limit at all.
None specified. This contrasts sharply with, for instance, the U.S. president, who generally must act on a bill passed by Congress within 10 days, excluding Sundays. If the U.S. president doesn't sign or veto within that time, the bill automatically becomes law unless Congress has adjourned, preventing its return, which is the specific pocket veto scenario in the U.S. But in India, the lack of any time limit gives the president the power to effectively kill a bill by simple inaction, by just keeping it in their pocket.
So the Indian president's pocket for holding bills is effectively unlimited in time.
Yes, the source uses that memorable phrase. It says, the pocket of the Indian president is bigger than that of the American president, to illustrate this crucial difference stemming from the absence of a constitutional time limit in India. It gives the Indian president a unique power to stall legislation indefinitely if they choose, without formally vetoing it.
Has this pocket veto ever actually been used in India?
Yes, it has. A very notable example mentioned in our source is from 1986. The then president, Gianni Zail Singh, exercised a pocket veto on the Indian Post Office Amendment Bill. This bill had been passed by Parliament but was quite controversial, with widespread criticism that it impinged on the freedom of the press by allowing mail interception.
So what did President Zail Singh do?
He simply took no action on it. He didn't sign it, he didn't formally veto it, he didn't send it back, he just kept it pending on his desk. Our source notes that the bill remained in limbo. 3 years later, in 1989, the next president, R. Venkataraman, took it out of the pocket and sent it back to Parliament for reconsideration. However, by then, a new government, the National Front government, was in power, and they decided to simply drop the controversial bill altogether. So the pocket veto effectively killed the bill during President Zail Singh's term.
Fascinating example of how inaction can be a powerful tool. So the president has these three veto powers: absolute, suspensive, pocket over ordinary central legislation.
Okay.
But is there any type of bill passed by Parliament over which they have no veto power whatsoever?
Yes, there is one very significant exception: constitutional amendment bills.
Bills to amend the Constitution itself.
Exactly. The president has no veto power over bills seeking to amend the Constitution that have been duly passed by Parliament, according to the procedure in Article 368. The 24th Constitutional Amendment Act of 1971 made it explicitly obligatory for the president to give their assent to any constitutional amendment bill presented to them after passage. They cannot withhold assent, they cannot return it for reconsideration, they cannot pocket veto it. Assent is mandatory.
That's a clear demarcation. The power to amend the foundational document of the country bypasses the president's potential veto. Very important point. Now, let's shift slightly to Section 13, veto power over state legislation. Does the president have a role in laws passed by the state legislatures too?
Yes, they do, but it's usually an indirect role, acting through the governor of the state. A bill passed by a state legislature can become an act only if it receives the assent of the governor, or in certain cases, the assent of the president, if the governor reserves it for the president.
Okay, so the process starts with the governor. What happens when a state bill goes to the governor? Our source outlines the governor's options under Article 200.
Right. When a bill passed by the state legislature is presented to the governor of that state, the governor has 4 alternatives.
4 choices for the governor.
Yes. 1, they can give assent to the bill and it becomes state law. 2, they can withhold assent from the bill, similar to the president's absolute veto. 3, if it's not a money bill, they can return the bill to the state legislature for reconsideration, similar to the president's suspensive veto. Or 4, and this is the crucial one that brings the president into the picture, the governor can reserve the bill for the consideration of the president.
Reserve it for the president.
Yeah.
Why would a governor do that? Are there specific types of bills they have to reserve?
Yes, there are some types of state bills that governors are constitutionally obligated to reserve, like those derogating the powers of the High Court. There are others they may reserve based on their discretion, perhaps if they feel the bill contradicts union law or national policy, or is of grave national importance, or undermines the Constitution.
Okay, so if the governor reserves a bill, it goes up to the president. What are the president's options then for such a reserved state bill under Article 201 of the Constitution?
When a state bill is reserved by the governor and presented to the president for consideration, the president basically has 3 options, similar to their options for central bills. 1, the president can give assent to the reserved state bill and it becomes a state law. 2, the president can withhold assent from the reserved state bill, effectively an absolute veto on state legislation. 3, if it's not a money bill, the president can direct the governor to return the bill to the state legislature for reconsideration.
Okay, so the president can also send a state bill back for reconsideration via the governor. What happens if the state legislature reconsiders the bill, passes it again, maybe with some changes, and sends it back to the president through the governor? Are they in the same position as the parliament is with a return central bill? Does the president have to assent then?
No, and this is a crucial difference the source highlights. If the state legislature passes the bill again, even with or without amendments, and it's sent back to the president via the president is not bound to give assent this time.
Really? So the state legislature cannot override the president's veto on a reserved state bill by simply passing it again?
That's correct. The Constitution does not compel the president to assent to a reconsidered state bill. The president can still choose to withhold assent even after the state legislature has reconsidered and repassed it. The president's decision is final for reserved state bills.
Wow. That gives the president considerably more power, a more absolute veto over state legislation that reaches their desk, compared to central legislation where Parliament can override the suspensive veto.
It certainly does seem that way based on the constitutional text. The state legislature's ability to legislate in certain areas is subject to this potential final check by the president, exercised usually on the advice of the union government.
Can the president use the pocket veto on a state bill that's been reserved for them? Just sit on it indefinitely?
Yes, just as with central bills, the Constitution doesn't prescribe any time limit for the president to take a decision on a reserved state bill. So the president can effectively keep a reserved state bill pending indefinitely, exercising a pocket veto on state legislation as well.
The source includes a table comparing the president's veto power over central versus state legislation, which probably summarizes these differences quite nicely.
Yes, that table, Table 18.2 in the source, serves as a helpful reference point. It reinforces the nuances for ordinary bills, money bills, and constitutional amendment bills at both the central and state levels when reserved, showing clearly where the president's power is constrained, like mandatory assent for central constitutional amendments, and where it appears stronger, like the ability to withhold assent even after reconsideration of a state bill.
Okay, that covers the veto power thoroughly. Let's move from reacting to legislation to initiating temporary laws. Section 14, the ordinance-making power. This is a power the president can use when Parliament isn't in session, right? To make laws quickly.
Correct. Article 123 of the Constitution empowers the president to promulgate ordinances during the recess of Parliament. These ordinances have the same legal force and effect as an act passed by Parliament itself, but crucially, they are intended to be temporary laws.
What is the main purpose of giving the president this power? Why not just wait for Parliament?
The stated purpose is to enable the executive, the government, acting through the president, to deal with unforeseen or urgent situations that require immediate legislative action, but where Parliament is not in session, or one of its houses is not in session, and therefore cannot enact a regular law quickly enough. It's a power meant for exigencies, for urgent needs.
So it's a power to act quickly when Parliament is away, but our source mentions it has critical limitations. It's not a blank check.
Absolutely not. This is not meant to be a parallel power of legislation allowing the president to bypass Parliament whenever they want. There are 4 key limitations outlined in the source material.
Okay, what's the first limitation?
Firstly, the timing. The president can only promulgate an ordinance when both houses of Parliament are not in session, or when either one of the 2 houses is not in session. Why either house? Because a law needs the approval of both houses to be enacted. So if even one house is not sitting, a regular law cannot be passed. However, an ordinance made when both houses are actively in session would be completely void. It's specifically for periods of parliamentary recess.
So only when Parliament can't legislate normally. What's the second limitation? It involves the president's own judgment, their satisfaction.
Yes, the second limitation is that the president can only make an ordinance if they are satisfied that circumstances exist which render it necessary for them to take immediate action. This satisfaction, the president's judgment call on the urgency, has actually been a subject of constitutional debate and judicial review over the years.
How so? Can the courts question whether the president was genuinely satisfied or if the situation was truly urgent? Our source traces the history of judicial scrutiny on this point.
It's an interesting legal history. Initially, the Supreme Court in the R.C. Cooper case, 1970, also known as the bank nationalization case, indicated that the president's satisfaction could potentially be questioned in court, specifically on the grounds of malified, basically, if there was evidence that the power was used for improper reasons, perhaps like deliberately proroguing, shutting down a House of Parliament, just to issue an ordinance and avoid legislative debate.
So the courts could look into bad faith. What happened next?
Then, during the emergency, the 38th Constitutional Amendment Act in 1975 tried to put a stop to this. It inserted a clause making the president's satisfaction final and conclusive, explicitly stating it couldn't be questioned in any court on any ground.
Trying to make it immune from judicial review. Did that stick?
No. After the emergency, the 44th Constitutional Amendment Act in 1978 deleted that clause introduced by the 38th Amendment, so the position reverted. The president's satisfaction in issuing an ordinance is justiciable, meaning courts can review it, but generally only on the limited ground of malified. So while courts won't second-guess the wisdom of the ordinance, they can intervene if it seems the power was exercised dishonestly or to subvert the legislative process.
Good to know there's still a check. What's the third limitation on ordinances? It relates to what subjects an ordinance can cover.
Yes. The third limitation is that the ordinance-making power is coextensive with Parliament's own legislative power in terms of subject matter. This means an ordinance can only be issued on subjects on which Parliament itself has the power to make laws, i.e. subjects in the Union list or concurrent list.
So the president can't use an ordinance to legislate on something Parliament couldn't legislate on anyway.
Exactly. And furthermore, an ordinance is subject to the same constitutional limitations as a regular act of Parliament. For example, an ordinance cannot violate fundamental rights. Article 13 of the Constitution, which deals with laws inconsistent with fundamental rights, explicitly includes ordinances in its definition of law.
So, same subject matter scope, same constitutional limits. What's the fourth limitation? This deals with its temporary nature and the need for parliamentary approval after the fact.
This is critical to understanding that ordinances are temporary. Every ordinance issued by the president must be laid before both houses of Parliament when they reassemble after the recess.
Okay, it has to be presented to Parliament.
Yeah.
Then what happens?
Parliament then has a choice. If both houses pass resolutions approving the ordinance, it effectively becomes a permanent act, or continues as law until its intended expiry, if any. However, if Parliament takes no action either way, the ordinance automatically ceases to operate 6 weeks after the date Parliament reassembles.
6 weeks from reassembly. That's a specific time frame.
Yes. It can also cease to operate even earlier than 6 weeks if both houses pass resolutions disapproving of the ordinance. And if the two houses reassemble on different dates, that 6-week period is calculated from the later of those two dates.
So there's a definite clock ticking once Parliament is back in session. This implies there's a maximum possible lifespan for an ordinance if Parliament doesn't act.
Yes, exactly. The maximum possible life of an ordinance is generally considered to be 6 months and 6 weeks. Why? Because the Constitution allows a maximum gap of 6 months between two sessions of Parliament. Add to that the 6 weeks provided for parliamentary approval or disapproval after Parliament reassembles, and you get that maximum duration.
6 months gap plus 6 weeks approval window equals max life.
Got it. What happens to things done under an ordinance if it eventually lapses or is disapproved? Are those actions undone?
No, our source clarifies that acts already done and completed under an ordinance while it was in force remain fully valid and effective, even if the ordinance subsequently lapses or is disapproved by Parliament. It doesn't invalidate past actions.
Can the president withdraw an ordinance before it runs its course?
Yes, the president has the power to withdraw an ordinance at any time, even before it's laid before Parliament or before the 6-week period expires.
Now, is this power to issue or withdraw an ordinance something the president can do based on their own personal judgment? Is it discretionary?
No, the source explicitly states that the ordinance-making power is not a discretionary power of the president. Like most of their powers, the president promulgates or withdraws an ordinance only on the aid and advice of the Council of Ministers headed by the Prime Minister. It's the government deciding an ordinance is needed. So it's an executive power clothed in legislative form, exercised on cabinet advice. Are there any other details about ordinances? Can they be retrospective, for example, applying to past events?
Yes, an ordinance can be made retrospective in its application. It can also modify or even repeal existing acts of Parliament or other ordinances. It can alter or amend a tax law.
But can it amend the Constitution?
No. Importantly, an ordinance cannot be issued for the purpose of amending the Constitution itself. Constitutional amendments require the specific, more rigorous procedure laid down in Article 368 involving Parliament directly.
Right. The source notes this ordinance power is somewhat unusual compared to many other established democracies like the US or UK. How is it justified by the constitution makers back then? Why do they feel India needed it?
Dr. B.R. Ambedkar, a key architect of the Constitution, addressed this in the Constituent Assembly. His justification, as explained in our source, was that it's essentially a necessary mechanism for the executive to deal effectively with urgent situations that might arise suddenly when Parliament simply isn't in session and cannot act quickly. It provides a tool for swift legislative response in emergent circumstances where waiting for Parliament to convene could cause delay and potentially harm public interest.
So a pragmatic tool for unforeseen urgency. And it's not necessarily linked to a national emergency being declared.
That's correct. Our source clarifies that the power to issue ordinances under Article 123 has no necessary connection with a national emergency declared under Article 352 due to war, external aggression, or armed rebellion. An ordinance can be issued to deal with any urgent matter requiring legislation during parliamentary recess, even if the country is perfectly at peace and there's no state of emergency.
Okay. Now, our source also brings up a significant issue that arose in practice regarding this power: the repeated repromulgation of ordinances. What was that about?
This became a serious point of constitutional contention and was eventually addressed decisively by the Supreme Court. While parliamentary rules require a bill replacing an ordinance to be introduced with a statement explaining the necessity, a practice emerged, particularly in some states, though the principle applies to the president's power too, of repeatedly reissuing the same ordinance over and over again, just before it was about to lapse, without ever making a serious attempt to get it passed as a proper bill in the legislature.
So, keeping a law alive indefinitely through ordinances, bypassing the legislature.
Essentially, yes. And the D.C. Wadhwa case, 1986, is the landmark ruling here, as mentioned in our source.
What happened in that case?
The case specifically dealt with the governor's ordinance power in the state of Bihar, but the principles laid down are considered applicable to the president's power under Article 123 as well. The Supreme Court was presented with evidence that an astonishing 256 ordinances had been promulgated and repeatedly repromulgated in Bihar between 1967 and 1981. Some of these ordinances were effectively kept alive for periods ranging from 1 to 14 years solely through this mechanism of repromulgation.
14 years without legislative approval. What was the Supreme Court's finding on this practice?
The Supreme Court condemned it in very strong terms. It ruled that such successive repromulgation of an ordinance with the same text, without bringing it before the legislature as a bill, constitutes a fraud on the Constitution and a clear subversion of the democratic legislative process.
A fraud on the Constitution. Strong words.
Very. The court held that such repromulgated ordinances are liable to be struck down as unconstitutional. It firmly reiterated that the power to issue ordinances is an exceptional power designed for emergencies and is absolutely not intended as a substitute for the lawmaking power of the legislature. Repromulgation undermines the legislature's role.
That Wadhwa case provides a vital judicial check, ensuring the ordinance power remains an emergency tool and doesn't become a way to rule by decree by passing democratic accountability. Very important clarification. Let's move now to Section 15, pardoning power. This seems like a very direct and significant power held by the president, almost like a final override on the judicial system.
It is indeed a significant power vested in the president by Article 72 of the Constitution. It's often categorized under judicial powers, although it's exercised by the executive head. It's a power of mercy or clemency.
In what kinds of cases can the president exercise this pardoning power? Does it apply to all crimes?
No, its scope is specific. The president can exercise this power in three main types of cases. Firstly, where the punishment or sentence is for an offense against a union law, a law made by Parliament or under the union's authority.
Offenses against central laws.
Okay. Secondly, where the punishment or sentence has been handed down by a court-martial, which is a military court.
So it covers military justice too.
Yes. And thirdly, and perhaps most prominently discussed, where the sentence is a sentence of death.
So it applies to federal law offenses, military court sentences, and all death penalty cases. How does the source describe the fundamental nature of this power? Is the president acting like a super judge?
No, the material emphasizes that this power is constitutionally independent of the judiciary. When the president considers a mercy petition, they are not sitting as a court of appeal reviewing the legal correctness of the conviction. They are exercising a distinct executive power of clemency, looking at broader factors, perhaps.
What are the stated objects or purposes of giving the president this power then?
The source mentions two main objects. One is to provide a final safeguard, a way to correct any potential judicial errors in the operation of law that might have occurred and cannot be rectified through the normal judicial appeal process. The second object is to afford relief from a sentence that, even if legally correct, the president might consider unduly harsh or where there might be other mitigating circumstances warranting mercy.
So error, correction, and mercy for harshness. Our source defines 5 different types of actions the president can take under this broad pardoning power in Article 72. Can we break those down?
Yes, the power isn't just one thing. It encompasses 5 distinct forms of clemency.
Okay, what's the first one?
Pardon. This is the most complete form of clemency. A pardon completely removes both the sentence and the conviction. It fully absolves the convicted person from all sentences, punishments, and disqualifications associated with the offense. It's like the offense never happened, legally speaking.
Complete absolution. What's next?
Commutation. This involves substituting one form of punishment for a lighter form. For example, a death sentence could be commuted to rigorous imprisonment for life, or a sentence of rigorous imprisonment could be commuted to simple imprisonment. The nature of the punishment changes to a less severe one.
Changing the type of punishment. Third.
Remission. This means reducing the period or duration of the sentence without changing its fundamental character. For instance, a sentence of 2 years rigorous imprisonment could be remitted to 1 year's rigorous imprisonment. It's still rigorous imprisonment, just for a shorter time.
Reducing the time, not the type.
Fourth, respite. This involves awarding a lesser sentence than the one originally given, specifically because of some special fact or circumstance related to the offender. The classic examples given are the physical disability of an offender or the pregnancy of a woman offender, which might make the original sentence inappropriate or unduly harsh.
Awarding a lesser sentence due to special circumstances. And the fifth one.
Reprieve. This isn't about changing the sentence itself, but rather granting a temporary stay on the execution of a sentence, especially a sentence of death. The purpose of a reprieve is usually to give the convicted person time to seek a pardon or commutation from the president, or to pursue other legal remedies. It's a temporary postponement.
Pardon. Commutation, remission, respite, reprieve. That breaks down the different levels of clemency available. Now, we know the governor of a state also has a pardoning power under Article 161. How does the president's power under Article 72 compare to the governor's power? Are they the same?
No, they're not entirely the same, although they overlap. The governor also has powers to grant pardons, reprieves, respites, and remissions. But the governor's power applies only to offenses against state laws.
State laws for the governor, union laws generally for the president. What are the key differences?
Our source highlights 2 crucial differences where the president's power is broader or exclusive compared to the governor's. First, the president can grant pardons, remissions, etc. in cases where the punishment or sentence was handed down by a court-martial. The governor has no power in relation to military court sentences. That's exclusively with the president.
Okay, court-martial power is only presidential. Second difference.
Second, and very importantly, the president has the power to grant a full pardon for a death sentence. The governor, while they can suspend, remit, or commute a death sentence, does not have the power to grant a full pardon that completely absolves someone sentenced to death, even if the offense was under a state law that prescribes the death penalty.
So only the president can grant a full pardon in a death sentence case. But they both have some power over death sentences.
Yes, that's the nuance. Both the president under Article 72 and the governor under Article 161 have concurrent power when it comes to suspending, remitting, or commuting a death sentence. But the power to grant a complete pardon for a death sentence rests solely with the president.
That's a critical distinction. Now, the Supreme Court has also weighed in over the years on how this presidential pardoning power should be exercised. The source mentions the Kihar Singh case, 1988, as laying down some key principles. What did the court establish there?
Yes, the Kihar Singh judgment is considered quite significant in clarifying the nature and scope of the president's pardoning power. The Supreme Court laid down several important principles.
Like what? Does the person asking for mercy get a hearing?
The court held that the petitioner seeking mercy does not have an absolute right to an oral hearing before the president. The process is generally based on written petitions and government records.
Can the president re-examine the case evidence?
Yes. The court clarified that the president, in exercising this power, can examine the evidence in the case afresh and is entitled to take a view that might be different from the one taken by the courts during the trial and appeals. They are not bound by the judicial findings in deciding on mercy.
How is this power actually exercised?
Yeah.
On whose advice?
The court explicitly affirmed that the president exercises this power under Article 72 on the advice of the Union Cabinet, the Council of Ministers. It's not a personal discretionary power.
Did the court set guidelines for using the power?
No, the court stated that it was not necessary for the Supreme Court itself to lay down specific guidelines for the president to follow when exercising this power. It's seen as a high executive function guided by cabinet advice.
What about judicial review? Can the courts review the president's decision on a mercy petition? If the president rejects a petition, can the person go to court?
This is a key point. The court held that the exercise of the president's pardoning power is not generally subject to judicial review on its merits. The courts won't substitute their judgment for the president's on whether mercy should be granted. However, there's a very important exception.
An exception?
Yes. The president's decision can be subject to judicial review if it is found to be arbitrary, irrational, mollified, meaning exercised in bad faith or for improper reasons, or discriminatory.
So, while the court won't review the substance, should mercy have been granted, they can review the process and ensure the decision wasn't completely arbitrary or biased.
Exactly. It provides a limited but necessary check against gross misuse or unreasonableness in the exercise of this very potent power of clemency.
That provides a crucial layer of accountability, even for this high executive power. So we've gone through this exhaustive list of formal powers: executive, legislative, financial, judicial, diplomatic, military, emergency. On paper, reading all this, the president looks incredibly powerful. It seems like they're involved in almost everything.
It certainly looks that way when you just list the powers, doesn't it?
Yeah. But this brings us right back to our core question, which is Section 16 in our outline. The constitutional position: is the president really just a nominal executive, despite all these formal powers? How does it all work in practice?
This is where the rubber meets the road, where the formal text of the Constitution meets the reality of India's chosen system of government. And the answer, fundamentally, lies in the context of that system. Our source reiterates that India adopted a parliamentary form of government modeled, albeit not identically, on the British Westminster system.
And in that system, as we said at the start, the head of state isn't the same as the head of government.
Exactly. That's the foundational principle. The president is the nominal or constitutional head of the executive. They are the head of state. The real executive power, the day-to-day running of the government and policymaking, is exercised by the Council of Ministers, which is headed by the Prime Minister.
So despite having all those extensive powers we just listed formally vested in them, the president largely acts only on the advice of the Prime Minister and the Council of Ministers.
Yes, that's the absolute core of their constitutional position in practice. Article 74 of the Constitution is the key here, and its wording is critical. It states, "There shall be a council of ministers with the Prime Minister at the head to aid and advise the President, who shall, in the exercise of his functions, act in accordance with such advice."
That word shall is crucial, isn't it? It implies compulsion.
Extremely significant. The use of shall makes the advice tendered by the Council of Ministers binding on the President. And Article 75 further reinforces the parliamentary nature by stating that the Council of Ministers shall be collectively responsible to the Lok Sabha, the directly elected House. This links the real executive power to legislative accountability.
Our source even quotes Dr. B.R. Ambedkar, explaining this position in very direct, almost blunt terms during the Constituent Assembly debates. What was his take?
Ambedkar's explanation, as quoted in the source, leaves very little room for doubt about the intended role. He stated quite clearly that the Indian president is intended to hold the same position as the king or queen under the English Constitution, that is, the head of the state, but not the head of the executive.
Represents the nation, doesn't rule it.
Precisely. Ambedkar said the president represents the nation but does not rule the nation. He described the president as essentially a ceremonial device or a seal through which the nation's decisions are made known. He was emphatic that the president is generally bound by the advice of his ministers and can do nothing contrary to their advice, nor can he do anything without their advice.
He even contrasted it explicitly with the U.S. president.
Yes, he drew a clear contrast, noting the U.S. president has the power to dismiss cabinet secretaries directly, whereas the Indian president does not have such power over ministers as long as those ministers command the confidence of Parliament. The power rests with a collective cabinet responsible to the legislature.
Those are very strong statements from a key architect of the Constitution, reinforcing the idea of a largely figurehead role, despite the formal powers. The source also traces how this binding advice principle evolved constitutionally, particularly with amendments.
Yes, the wording of Article 74(1) wasn't always as explicit as it is now. Initially, it just said the president shall act on advice, but there was perhaps some room for interpretation about whether it was absolutely binding in all conceivable situations.
So how was it clarified?
The 42nd Constitutional Amendment Act, passed in 1976 during the emergency period, made the position unambiguous. It explicitly inserted words into Article 74(1) to state that the president shall act in accordance with such advice, effectively making the advice tendered by the Council of Ministers binding on the president without exception.
Made it absolutely binding. But there was a further change after the emergency.
Yes, the 44th Constitutional Amendment Act, enacted in 1978 by the post-emergency Janata Party government, revisited this. It didn't remove the binding nature entirely, but it did introduce a significant modification. It added a proviso to Article 74(1), which authorizes the president to require the Council of Ministers to reconsider the advice they have tendered, either generally or regarding a specific matter.
So the president can say, think about this again.
Exactly. They can send the advice back once for reconsideration. However, and this is crucial, the same 44th Amendment also maintained that the president shall act in accordance with the advice that is tendered after such reconsideration.
So they can send it back once, ask the cabinet to have another look, maybe raise some concerns. But if the cabinet insists and sends back the same or slightly modified advice, the president then has to accept it.
Precisely. This gives the president a limited but potentially significant power to pause, to ask questions, to urge caution, perhaps even to influence the cabinet's final decision by forcing them to reconsider. But ultimately, the final decision-making authority rests with the Council of Ministers, who are accountable to Parliament. The president cannot ultimately reject the reconsidered advice.
A power to question and delay, but not to block indefinitely. Our source gives some specific examples where President K.R. Narayan actually used this power of reconsideration, particularly related to imposing president's rule in states. Those are quite interesting.
Yes, they are compelling real-world examples of this power in action. In October 1997, the Union Cabinet recommended imposing president's rule in Uttar Pradesh under Article 356. President K.R. Narayan, however, had reservations and returned the recommendation to the cabinet for reconsideration.
And what happened?
The cabinet, after reconsidering, decided not to proceed with imposing president's rule at that time. The president's intervention led to a change in the government's course.
That's significant. Any other examples?
A similar instance occurred in September 1998. The Union Cabinet again recommended imposing president's rule, this time in the state of Bihar. President Narayanan, once again, sent the recommendation back to the cabinet for reconsideration.
Did the cabinet back down that time too?
Not entirely. The cabinet did reconsider, and some months later, in February 1999, they resubmitted the advice to impose president's rule in Bihar. This time, President Narayanan, being bound by the reconsidered advice, signed the proclamation, and president's rule was imposed. However, these instances, especially the UP one, demonstrate that the power to ask for reconsideration is not purely ceremonial. It can, at times, lead the cabinet to genuinely review, modify, or even drop its initial recommendation, particularly on sensitive issues.
So while the president is mostly bound by advice, and even reconsidered advice is binding, are there any situations at all where they might have to use their own judgment, where there might not be clear ministerial advice, or where following the advice might seem constitutionally problematic, moments of genuine discretion?
This is a very important nuance. The source clarifies that while the president doesn't have constitutional discretion in the sense of having the explicit right to act against or without ministerial advice under Article 74, they do possess what is often termed situational discretion.
Situational discretion. What does that mean?
These are specific, usually politically complex or ambiguous circumstances where the normal conventions of parliamentary government might not provide a clear, automatic answer, and the president must use their own judgment, exercising discretion based on the situation, primarily to uphold the Constitution and ensure the continuity and stability of government.
When might such situations arise? What are the key examples of this situational discretion mentioned in the source?
The material highlights three main situations where the president's situational discretion comes into play.
Okay, first one.
First, and perhaps most critically, is in the appointment of the prime minister. This discretion arises when no single political party or pre-election coalition secures a clear majority in the Lok Sabha after a general election, Or it could arise if the prime minister in office dies suddenly and there's no obvious or unanimously agreed upon successor within the ruling party or coalition.
A hung parliament or sudden death of a PM.
Exactly. In these fluid situations, there's no automatic choice. The president has to use their judgment to assess who among the potential claimants is most likely to be able to form a stable government and command the confidence of the Lok Sabha. That's a major exercise of discretion.
A critical moment for the president to exercise judgment, potentially shaping the country's political direction. What's the second situation for discretion?
The second is the dismissal of the Council of Ministers. Now, we know ministers formally hold office during the president's pleasure, but this isn't arbitrary. However, a situation could arise where the Council of Ministers loses the confidence of the Lok Sabha, perhaps demonstrated by losing a vote of no confidence but refuses to resign. In such a scenario, the president can exercise their discretion and dismiss the ministry as it no longer commands parliamentary support.
So, enforcing parliamentary accountability if the government refuses to accept defeat. And the third situation. It involves dissolving the Lok Sabha.
Yes, the third main area of situational discretion is the dissolution of the Lok Sabha. Normally, the president dissolves the Lok Sabha on the advice of the prime minister, usually to call fresh elections. But what if the Council of Ministers has clearly lost its majority in the House, yet advises the president to dissolve the House anyway, perhaps to avoid facing defeat or allowing an alternative government to form?
Can the president refuse that advice?
Yes. In that specific situation where the government has lost its majority but advises dissolution, the president is not necessarily bound to accept this advice. They can use their discretion to explore whether it's possible for an alternative government to be formed that can command a majority in the existing Lok Sabha. If they believe an alternative is viable, they might refuse dissolution and invite someone else to form the government, thus potentially avoiding premature or politically motivated elections.
These moments of situational discretion are fascinating, aren't they? Because they show that while the president is largely bound by advice in the day-to-day running of things, they are not a complete rubber stamp. They seem to have a crucial, albeit limited and exceptional, role as a constitutional guardian or a safety valve, stepping in with their own judgment when the usual political process is unclear, deadlocked, or potentially breaking down.
Exactly. These are the specific junctures where the president's office moves beyond the purely ceremonial and involves a degree of independent judgment, guided by the need to ensure that the democratic and constitutional framework is maintained, particularly regarding government formation, stability, and accountability to the legislature.
It adds a layer of complexity to the nominal executive label. They're nominal most of the time, but potentially pivotal in certain crises.
That's a good way to put it. The power lies dormant most of the time, but can become very significant in specific circumstances.
Our source also conveniently lists key articles related to the president in a table, Table 18.3 it seems, which is useful for reinforcing the constitutional basis of everything we've discussed. Just quickly referencing some key ones.
Yes, that table is a handy quick reference. It covers the most important articles, like Article 52 stating there shall be a president, Article 53 on executive power being vested in the president, Article 54 on the election, Article 61 on impeachment, Article 72 on the pardoning power, Article 74 on the Council of Ministers aiding and advising, Article 111 on assent to bills, Article 123 on the ordinance power. It really provides the specific constitutional anchors for the president's role, powers, and limitations we've explored.
Wow, that was indeed a comprehensive deep dive. We started by asking about the reality behind that powerful image of the President of India residing in Rashtrapati Bhavan.
And we've really navigated through quite a bit, from their role as the formal head of state and symbol of national unity.
Through that intricate, unique process of their indirect election via the Electoral College, with its weighted votes carefully designed to balance federal representation between the states and the Union.
We looked at the specific qualifications needed: age, citizenship, Lok Sabha eligibility, the solemn oath they take to preserve, protect, and defend the Constitution, and the conditions of their office, including those significant entitlements and legal immunities.
We explored their fixed 5-year term, the possibility of re-election, the very high bar set for removal through impeachment, and the detailed constitutional provisions for handling vacancies and ensuring continuity through that established line of succession.
Then we cataloged their extensive formal powers listed across those 7 different domains: executive, legislative, financial, judicial, diplomatic, military, and emergency powers, seeing the vast areas where the president's formal authority is invoked on paper.
We dissected the critical veto power, understanding the different types the Indian president wields: the absolute, the suspensive, and that unique pocket veto, and crucially, how their power differs when dealing with central legislation versus state legislation reserved for their consideration.
We examined the unusual ordinance-making power, an extraordinary tool for temporary legislation when Parliament is in recess, but we also highlighted its strict limitations regarding timing, justification, scope, parliamentary approval, and the Supreme Court's important check against misuse through excessive repromulgation, thanks to the Wadhwa case.
And we explored the significant pardoning power under Article 72, its scope covering union laws, court-martials, and death sentences, comparing it carefully to the governor's more limited power, and noting the Supreme Court's principles on its exercise, on cabinet advice, and the possibility of limited judicial review for arbitrariness or malefides.
Finally, we circled back and grappled with the president's overall constitutional position, reconciling that impressive list of formal powers with the operational reality of being largely a nominal executive, bound by the aid and advice of the Council of Ministers as mandated by Article 74, especially after the 44th Amendment clarifying the send back once rule.
While still acknowledging those crucial, though infrequent, moments of situational discretion, appointing a PM in a hung parliament, dismissing a ministry that lost confidence, or dissolving the Lok Sabha, where the president's independent judgment becomes necessary to navigate political uncertainty and uphold the constitutional order.
It really paints a picture of an office deliberately designed with inherent checks and balances, reflecting India's specific choice of a parliamentary system where formal headship is consciously separated from the active, politically accountable head of government, the Prime Minister.
So here's a final thought perhaps for you, our listeners, to ponder after this deep dive. Considering that the president's extensive formal powers are mostly exercised on ministerial advice, yet they retain this significant situational discretion in moments of political crisis or uncertainty, how does this unique balance shape the stability and the day-to-day functioning of India's parliamentary democracy? Is the president primarily just a symbolic figurehead, a constitutional monarch equivalent? Or does that potential role as a constitutional backstop, a guardian in critical junctures, give the office a deeper, albeit less frequently seen, practical significance?
It's really a question about the interplay between written rules and unwritten conventions, the evolving nature of the office over time, the personalities who hold it, and ultimately that oath, the president's fundamental duty sworn before taking office, to preserve, protect, and defend the Constitution of India itself, sometimes even needing to act as its final check.
Thank you for joining us for this deep dive into the intricate, complex, and truly fascinating world of the Indian presidency, drawing directly from the detailed insights of our source material.